sir will join within the next 5 to 7 minutes. Hi everyone, am I audible? Can someone I would like to request you all to keep your camera on and mic switched off during the meeting. And do not share screen during the meeting. If you have any questions, please write in the chat box.
Hello, good morning. Can you hear and see me?
Yes, sir.
Okay. Well, wonderful to see you again. Good morning, good afternoon, India time. For some reason, I don't know why, it didn't get through to me that, well, let me start with this. Some people may have their microphone on, and because I hear all kinds of noises. So can you switch off the microphone, please? Unless you have to speak, of course. But thank you. Yeah, this is much better. Thanks a lot. Apparently, there is a time difference between India and continental Europe, Amsterdam, where I'm located, of 3.5 hours. I mean, 30 minutes. And that's, that never, I never realized that. I almost daily talk to contacts in India, but I was thinking it was 3 hours time difference or 4. No, it is 3 hours and 30 minutes. Okay, so I learned a new lesson today. All right, again, welcome everybody. Wonderful to see you. Let me start by asking, do you have anybody have a question right now in general about issues, matters, topics addressed yesterday? Does anybody have a question for me now? And by the way, I don't think I mentioned that yesterday, that you can interrupt if you have a question, no problem at all, interrupt. Just ask the question. You don't have to wait until the last moment that we stop the lecture today. You understand? Does anybody have a question? Or something to say, comment? No? Everything all right so far?
Sir, can I give a quick introduction
Yeah.
before we start?
Sure.
Good afternoon, everyone. Thank you for joining the day 2 of the lecture on international and Indian aspects of aviation financing and leasing laws by Professor P. Patrick Humber. I would like to start introducing the organization that gave us a chance to be a part of this session. The Amicus Curiae is the brainchild of several legal luminaries and eminent personalities across the country and the globe. It is an online platform which aims at proliferating legal knowledge and providing an ingenious understanding and cognizance of various fields of law to make sure that legal knowledge and experience penetrates to every nook and corner of the ever-growing legal fraternity. Through ambitious and studious legal brains across the country, the Amicus Curiae aims at providing valuable contributions to contemporary legal issues and developments in the omnipresent field of law to the masses. I would like to introduce our speaker for today. Patrick Hornby is one of the few aircraft finance lawyers having obtained the benefits of both worlds. While he is a long-standing academic, he also has vast practical expertise in realizing international aviation finance and lease transactions. The combination of extensive scholarly legal knowledge and his direct application in practice makes him a well-rounded aircraft finance lawyer. Now I would like to ask Professor Hornby to continue with the session.
Thanks a lot for the introduction. And again, I really appreciate inviting me and your kind words. I really, really like teaching. As you say, a part of my background is academic, and until today, I really appreciate that. And because it is important to teach students, and certainly in regard to this special, we call it a niche. The French word niche means a small area of law, but it is an important area of law, and it is within aviation law. In my book, it is very important because there is aviation law, but what is aviation law in general? A variety of topics, matters, and frankly, the people that are practicing aviation law, they are often specialized in one area, let's say liabilities, because accidents, crashes, that kind of area of law, or competition, whatever. And then there is also aircraft financing and leasing, but I think that aircraft financing and leasing laws, international and local aspects, are extremely, or actually in the natural order of things, in a chain of events. Number one, because, as I said yesterday, most carriers, airlines, but also private organizations, corporations having private jets, most, to need an aircraft and you can only get it, but you need the money. Or one way or another, you finance it, the acquisition, or you lease it. But then if you lease it, then also the lessor, the leasing company, needs money to acquire these aircraft. Now, without airplanes and without engines, remember what I said yesterday, engines are leased, financed separately from the airframe these days. Without those objects, there is no business. We can all go back to what? Riding a bicycle in the Netherlands and China, or a camel, or an elephant in India, whatever you want. But if you know what I mean, because there is no aviation. You don't need airports, there are no crashes, there is no competition, you don't need it. So, but that is underestimated. Now, in any event, I like teaching about that. It is very important, but at the same time, I also practice, and to give you an example, I think I didn't mention it yesterday, that yesterday was also due the realization, or what we call the closing, of a transaction, and my law firm was, or is, representing a major aircraft lessor from the United Arab Emirates, Dubai, precise. It is called the Dubai Aerospace Enterprise, which is a part of the large conglomerate which also owns Emirates, the airline, and which controls ultimately financially by the Dubai royal family. Now that was due yesterday, but for whatever reason, it will now take place on Monday. So what I'm trying to say, indeed, thank you for your introduction. I do both, and I can assure you, for an academic and practitioner, being able to do these two parts, teach and practice, that is basically kind of heaven, because then you learn academia, what is the law really, right? And at the same time, you can practice it. So whatever your future will be, not everybody can do so, but this is kind of heaven, I think, for lawyers to do. Okay, now, as I said, anybody question? No, otherwise questions later, okay? Shall we start then with the presentation of today? Can you pull up the slides, please? It concerns two court cases. Both are English cases. The first one is an international case, which has no direct immediate contact with India, but as I mentioned yesterday, almost in all, really, I think, I don't know exactly, but let's say 95% of transactions in India, aviation leasing, aviation finance transactions, they will have a clause in it, a condition in that lease agreement or in that mortgage agreement, that English law applies and not Indian law or Dutch law or Singapore law or Hong Kong or whatever law. No, not Indian law. Right? So for this very reason, this ruling is also important for the world at large, but also for India, or in particular for India. And I have been told that there is, by the way, an agreement between the state of United Kingdom and India in regard to the recognition of foreign judgments, in the sense that if there is an English case like this one, having not directly to do with India, that India will accept the decision, the ruling, without having to go to court in India again. And that is, of course, very important. Right. Now, this case, it is called, there are two cases, in fact, Blue Sky, Mahan Air. Can you possibly enlarge this or not? Full scale, or is that impossible? That the slides are larger? Is that possible, or is that difficult? Or only the middle slide, not the ones on the left, everything. Is that possible, or is it not possible? Yeah, I leave it up to you. You can read it hopefully. Now, Blue Sky, Mahan Air, 2010. And, oh yeah, I forgot to mention, which, let's say, jurisdictions and their local laws are in the international finance and lease world most popular. Now, I already said English law is one, and the other one, which is popular, is New York law. And it is important that you realize that choosing either English or New York law is done, I think, because the dominating law firms are located in New York or in London, basically. And whether there is a real need to choose either English or New York law, yeah, that is an open discussion. I do certainly not agree with it, because today we will address, I think, at least a couple of court cases having to do with India, but and this one not directly, but they are not really grand. What happened there in court, and relying on a local representation of English solicitors and barristers, it didn't turn out that great for the worldwide industry. It didn't. But still, until today, particularly the, let's say, previous colonies of Britain, like India, they choose English law. And please don't forget that there is no such thing as United Kingdom law in regard to private law, aircraft finance lease law. There is no such thing as United Kingdom law. There is a big difference between, for example, Scottish law, applicable in Scotland and England. And the industry wishes to be in England, in London. And that is expensive, as I mentioned already yesterday, taking a long time, but that is the way it is. Because Scottish law is not common law. Remember, it is a continental European civil law, derives back from Roman law, while English law is common law, right? You know that, like Indian law. Now, so they go for English law to be applied by English courts. That choice of law and jurisdiction is made, right? Now, is that grand? That is now the question. Here we go. Blue Sky. Blue Sky, 2010. That was a disaster for the industry at large. I must say that the Cape Town Convention, which will be addressed more detailed later, did not apply in this case, because the United Kingdom at that time had not yet, today yes, and not ratified the Cape Town Convention. Now, what happens here? Can we go to the next slide, please? Can we go to the next slide? Okay. I told you already yesterday that every country has adequate, some, or most inadequate laws. And the law exists, I'm not sure, because you are studying at different universities at different years, whether you already have been taught the differences between substantive laws, and then I am talking today particularly about substantive property regimes, so not contract law. I'm not talking about contract law. No, no. We are addressing property law, right? Property law means that a party, a secured party, has an interest, a secured interest in an object. And that is the difference between contract law and property law. It can uphold its secured interest against the world, which we in academia and also practice call erga omnes Latin. I don't know whether in India they are teaching you a lot of Latin expressions, terminology. But anyway, you can, when you register that secured interest in a certain registry, you can uphold it against the rest of the world. Erga omnes in Latin. You can uphold it against anybody. So not only against your contract partner, for example, lessee versus lessor, or lessor versus lessee, or mortgagor versus mortgagee, etc., etc. No, you can uphold it against the rest of the world, provided that you have registered your interest in some kind of registration system, so the rest of the world is aware, can see that you have that, for example, mortgage, Indian mortgage, English mortgage, Netherlands mortgage, in a certain object like real estate, a house, an office, land, or aircraft, or engine, right? So that's what we call property law, and that is decisive, the most important area of substantive law there is in international aviation financing and leasing transactions. So contract law, yeah, it is there, and it is of course important, but you see, the problem is that contract law can only be enforced as between the parties. And if the lessor goes bankrupt, and that happens these days, you'll see, a lessor can also go bankrupt, but certainly lessees, operators, you'll see today, go bankrupt, then that whole contract is worthless, because third parties who are not agreeing, a part of the agreement, they are not a party, have nothing to do with what the parties agree to in the lease agreement. They didn't agree, they didn't sign, they are not a party to it, so they say forget it. Now, and for that very reason, in the international aviation finance and leasing world, contract law is of less importance. Nevertheless, it is important as long as the two parties agree, and they write down in detail, as I said yesterday, hundreds of pages, what lessor has to do, what lessee has to do, what mortgagor has to do, what mortgagee has to do, but those are basically, in essence, these days standard agreements. You know, you just, when you are a lawyer working in this area of law, what you do is, yeah, okay, you have your standard agreements, and you already have your clients, and one client like this agreement, standard, and the other one has that standard, but to a large extent, all those agreements, those lease agreements, those mortgage agreements, pledge agreements in aircraft engines, whatever you want to call them, they are mostly standardized. So it is very easy, you push the button of your computer, you change the names, and here and there you do this and that, and update it a bit or whatever. But contract law, yeah, okay, there are of course difficulties when both parties are still alive legally, but as soon as one is going bankrupt, you know that, then it goes belly up, and then it means it's the end for that party. And then third parties come in. They start arguing, hey, listen, I've got a better right than you, lessor, under pursuant to my local law. or international law, international conventions. I've got a better right than you, lessor or bank or mortgagee or sorry, mortgagor, lessee, etc., etc., etc. So what is important is property law, which exists because you really want to register your secured interest in a registry so you can uphold it against the whole world in the event that, for example, the Cape Town Convention is applicable. Now, what is the other area of law which is extremely important, and certainly when the Cape Town Convention is not applicable, because not every country has adopted that Cape Town Treaty, remember, 80 today European Union to some extent, but not every country. And remember what I said, that, so for example, India and some other countries are creating big issues because they didn't implement it locally and they don't even apply it, or whatever reasons they have, they just don't listen to the Cape Town Convention like India, we will see today. So then what is important, that is the second area of law, which is absolutely then significant, that is conflict of laws. And I'm not sure, because I don't know how far you are already, whether each of you students have already been taught about conflict of laws. And that is extremely important, like in this case, Blue Sky and Mount Air, because Cape Town did not yet apply. If Cape Town, by the way, is a substantive property law regime, so that takes away the issues of conflict of laws. Now, so each country has different substantive property laws, mortgage laws, change of title laws. You purchase an aircraft or an engine or a helicopter. When are you the owner? What moment shifts title to from one to the other party, etc., etc. Is your mortgage valid? Can you enforce it locally, internationally? That is the issue, and you have to look, when Cape Town is not yet applicable, you have to look at local conflict of laws rules. Like in this case, like in India, because India doesn't apply Cape Town yet properly. Right? Okay. All right. But this creates, of course, economic risk, legal uncertainty. Which law applies? Which conflict rule? Which property law? Now, economic risk, and therefore, remember, you and I have to pay, for no reason, too high prices for tickets flying. But by the way, the same goes for trains financing. And while I have never been to India, it's in sight. I only have seen so far airports like Delhi, but there are still running a lot of trains in India. People that cannot afford flying, or for whatever reasons, they take trains. And these need to be financed in many countries too, unless they are just, it is a state-controlled business. Now, all right. And remember the lack of knowledge of lawyers. They just have not been taught in school or taught by their superiors, their senior partners, and they are making a mess of it. And that is typical for this case. Can we go to the next slide, please? What happened in this case? Now, I can already start by explaining who the parties are, but can you turn slide, please? Okay. Blue Sky. One of the parties is Blue Sky. And Blue Sky was a conglomerate of English companies. Basically, the owners of Blue Sky 1, Blue Sky 2, Blue Sky 3, special purpose vehicles, special they special? Because they are created as a company under English law, like here, for the only purpose to own one airplane, or maybe two airplanes, it doesn't matter. But all they do, that company has as an asset, only one asset, and that is that certain aircraft, including engines, or maybe two, you understand? But in this case, Blue Sky, 1, 2, 3 different English companies, each owned one Boeing 747 wide-body big airplane, which they had purchased second-hand from an airline which was having financial difficulties, and each of Blue Sky. Is it possible to turn the slide, or are having we trouble here? Or can you hear me at least?
Yes, sir, we're doing
Yes,
it.
sir, you're on.
Oh, all right. Now, so in total there were six Boeing 747s, which were going to be owned by Blue Sky 1, Blue Sky 2, etc. All right. Here we go. You see 747 aircraft. Now, and they were secretly the aircraft lessor, which had to be financed to purchase the airplanes by a bank in New York, United States bank. The lessor and the lessee, the lessor was leasing those aircraft to an operator in Armenia, in Eastern Europe, near Turkey, right? In Armenia, but secretly, without the knowledge of the lessor and of the bank in New York, they were operated, subleased, you can say, subleased. They were leased to Armenia, a company, but in secret they were subleased to a sublessee by the Armenian sublessor, we call them, to Mahan Air in Iran. You understand? Mahan Air is an airline which until today is operating old aircraft because of the issues in Iran. But the matter, what is important, is that the lessor and the bank in New York were not aware of this. And you may wonder, how is that possible? But it is possible. It is possible. You know, to give you a little insight how it goes in practice sometimes, the parties, when they are, like I just said, my firm representing a lessor and doing a transaction at the closing day even, everything is computerized, right, these days. You don't see your clients anymore. You don't hardly ever talk to them on the phone even. It's all done computer. They sign, signatures are no longer live, if you know what I mean. But anyway, so the day of the closing, then you may ask, for example, does anybody know where the aircraft at issue, the aircraft in question, the transactional aircraft, where it is? Where is the aircraft? Does anybody know right now, today? No. Then it is a big silence. Nobody knows where that aircraft is. Maybe it is flying, maybe it is grounded somewhere, and nobody knows. And that is a point which is important today. But that's how practice is. And in this case, we'll see that Mahan Air tried for the court, to the court in the UK, London, tried to establish that one certain aircraft was in Iran at the time that the mortgage was created in that aircraft. We'll see that in a moment. But it couldn't prove it. It could not even prove that that aircraft had been operated for, let's say, 2-3 months in Iran. You couldn't prove it. That's how it works. Very strange, but that's the way it is. Now, the problem here was in this case that the United States, until today, and also Europe, by the way, European Union, they are having sanctions. Iran, you know this. That particularly the United States is very tough about this. Europe also, but yeah, everybody is totally afraid of the US, because if you are getting on the US list yourself, they blacklist, well, then you can forget doing business in the US. And nobody wants that. So the US government one day found out that Boeing aircraft 747s were operated by an Iranian airline. And that's a no-no. So they said to the stakeholders, the bank in New York and the lessor in England, hey, listen, what you're doing, this is no good, so stop. Cancel whatever agreements you have undertaken, signed, business you've done. No. And that is how this case started, 2009, 2010. Can we go? Okay, and I said, yeah, in this case also very bad lawyers, both English and from my country, because my country also played a direct role in this case. The court there, of course, the justice, yeah, what can he do? He listens to parties and then he makes up his mind. But if the barristers and solicitors, if they give him all kinds of information, and that is all nonsense, yeah, then he's doing what he has to do, rule. And he ruled badly, due to a large extent because of those bad lawyers in the Netherlands and in England. Can we go to the next slide? Thank you. Now, here you see, that is, you can see there was a sales agreement, there were six in total, the transaction, Boeing 747s, purchased by Blue Sky, special purpose vehicles. They were lessor, owner, England, the bank, BK Air Finance, bank, mortgagee in New York, US, right? So there was a sales agreement, you can see that, purchase. Secondly, English mortgage and we are focusing on two aircraft, okay? 2 out of 7 played a role in these cases. Okay, 2 747s. Okay, mortgages, 2 in each, 1 in each aircraft. The aircraft were leased Blue Sky to Blue Airways in Armenia and secretly subleased, chartered, you may say, to Mahan in Iran. That is how it worked. Can we go to the next slide, please? What is now the court case? In the event that you want to look into it, maybe whatever you want to do, write a paper or anything, there are several publications about this because it, as I said, it had a major impact on the industry at large. But what happened is, so odd actually, is that the aircraft had the registration, the flag of the UK, right? English nationality, UK nationality, okay. All right, and in that aircraft was established, created an English mortgage. And that was not in 2016, that is a typo, it was 2006. So I'm sorry for that, but that doesn't matter, right? So now, the 2 aircraft were English aircraft, had English mortgages created in them. There was an English chosen law in the mortgage agreement, also in the lease agreement. Everything was English, and the whole trouble started because of the US boycott of Iran, and they went to court as they had chosen in England, and the court was supposed to apply because they had chosen English law. not the same in the Netherlands, in the US, in Brazil, wherever. And almost, yeah, I would say almost all countries, at least sophisticated ones, have conflict of laws rules. I told you that those conflict of law rules are important. Why? Well, a court like this in England or India, it sits, the court is there to just the judge one or more. They are considering in a case like this, hey, there are what, 5 countries involved? US, New York, US, England, UK, the Netherlands, we'll see, etc., Iran, Armenia. Which law am I going to apply? Because I do not always apply my own English law. I do not do so in the interest of the parties. It is an international case, so not necessarily will I apply English law. I will only do so if my own conflict of laws rule refers to English law. Otherwise, I may apply Dutch law from Netherlands, or Iranian, or New York, right? Because the term already says it, conflict of laws means there is a conflict between all those states which have direct contact with this transaction. There is a conflict between the laws. They are not the same, they are different. And the court has to decide, using its conflict of law rule, which refers it to a certain legal system, and this a property law system, and preferably a special aviation property law regime, if that is there. If it isn't, it has to apply general property law, not aviation specific. And that is what the court is doing. It is wondering, okay, what is my conflict of laws rule that refers me to the national law, substantive property law of that mortgage which is disputed today in front of me, the validity of that mortgage, and can that mortgagee, the bank in New York, enforce its secured rights under that mortgage. That's how it works. So first, the court, because Cape Town was not applicable, the court says, what is my conflict rule? Which national regime, property law, aviation related maybe, am I going to use to decide whether this certain, in the 2 aircraft, these 2 English mortgages, whether they are valid or not, and whether they can be enforced or not. I hope that is clear. That is how it works. Right? So, and that was a big issue. What is now in England, in the English courts, remember, Scotland may be totally different, but what is the English conflict of law rules, which refers this court to which local substantive law about mortgages, creating it, validity, and enforcing it. That is what it had to do. And that was not easy. That was not easy. Can we, yeah. Now yeah, let's go to the next slide, please. There are different conflict of laws rules applicable in countries. India different maybe than England, England different than Netherlands, Netherlands different than any other country, right? Now, what did this court do? That was a mistake, I can already tell you. The court said, you know what, I'm going to investigate, like in India, to have earlier court decisions, possibly of higher courts, and they have priority, right? The court in this case as well looked for earlier English rulings, court rulings. That is what it did. And it said there are earlier rulings, and they didn't look like this case, but nevertheless the court did so, and it said, you know what, my conflict of law-through is what we call, again in Latin, I'm sorry, again, I don't know whether you get Latin in law school in India, but in any event, it is called the lex res ipse or the lex situs. The court is referred to the situs. Where is the object, the aircraft in this case, located at the time that the mortgage was created in it? Where was it? Or for the same, where was the house? Now that is easy because a house doesn't fly away. Or where is the bicycle? Or where is the whatever kind of equipment, mobile or immobile? It doesn't matter. But this is in substantive law. It is the prime rule. You apply the law of the state in which the object is located. Now, that is not a problem, as I said, for immovable property, real property, land, houses, offices, because they're always there, and the law applies in India to housing, mortgages in housing, surely, etc., etc. That is no problem. But as I already discussed yesterday, yeah, engines and aircraft, airframes, they are extremely mobile. They move around all the time from one country to another country, or even within a country. Remember, like the United States, there is a difference in property law between New York, which everybody likes, and, for example, California, Texas, Florida. There are differences still until today. You see? So, aircraft, even within the US or in Canada, the same. The provinces of Canada have different laws. All right? Now, these aircraft move around even within one country all the time or internationally. So, where is that aircraft? Where is that aircraft? Now, what happened in this case, that one of these two aircraft was in the Netherlands, in Amsterdam, here around the corner from where I am having my office. That is at Amsterdam Airport. It was parked there at KLM, Royal Dutch Airlines, because it was having an overhaul. It was, let me put it this way, repairs. So it was in the Netherlands, not solely for 1 hour or two to let passengers out, disembark and embark and fly away for a couple of hours. No, it was a bit longer, but the same question arises if that aircraft is solely here for 2 hours, remember, or flying across the Netherlands, then what is the situs of that aircraft if you can locate it and say, okay, exactly, that mortgage was created at 7 o'clock in the morning on that day of that year. Now, where was the aircraft? And you can locate it, then that, the law of that country where it is located, the situs, that law will decide the validity of that English mortgage and not English law. Despite the fact that it was an English aircraft, English mortgage, chosen English law, English court, everything English, 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 but the court said, my conflict of law rule says I must apply the law of the situs, and it has been established that it was in Amsterdam, and the lawyers representing the parties today in front of me are saying, under Dutch law, that mortgage is not valid, Your Honor. My lord, I think they say in England. In any event, so his lordship said, well, you know, you tell me that under Dutch law that English mortgage is not valid, so it is not valid, so you cannot enforce it, so your $43 million, $43.1 million mortgage is not valid, goes down the drain, so too bad. You can imagine that this was not really welcome. in the eyes of the international aviation finance and lease industry because, remember, London rules the sky, right? Everything London, 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 England, right? So this was not welcome. And was this decision now correct? Can we go to the next slide? That decision was not right because you can see, let's see, 1, 2, 3, from above, third alinea sentence, the court said, even recognizing that the aim of our private international law, that is conflict of laws, is to identify the most appropriate law and appropriate principles to meet particular situations like this, in this case, this is a bold submission that I must apply not the law of the CITES, not that, but I must, that was argued by the lawyers of the mortgagee and the lessor, etc. Those that side, they said, Your Lordship, you must apply not the law of the CITES, Dutch law, you must apply the law of the aircraft's registration. The aircraft registration, and that is United Kingdom, and chosen is by the parties English law. So please apply English law and not Dutch law. But the court said, well, in previous court cases, I don't find support, and I don't find any support in literature, academia, writing. I don't find it. So I'm not going to apply the registry, registry, we call it, Latin, conflict rule. I'm not going to apply English law. It's refused. And you see, this was wrong because when you really look carefully, that is the problem with those Dutch and English barristers, lawyers, they did not argue sufficiently that that is absolutely not the case. The court cases, older court cases, were totally different than the one at hand, to begin with. Yeah, some may be aviation related, 1 or 2, but different, having nothing to do with this, and then also the outcome of those cases was wrong, and in literature, academia, writings, PhDs, etc., etc., you will find no support for the lex citus, but support for the state of registration, in this case, United Kingdom. You should apply the law of the state of registration of the airplane because there is a direct contact with that country. It is an not English, United Kingdom aircraft. Like you have passport India, you have a direct connection with India, you are Indian citizens. These aircraft are kind of UK, objects, citizens if you wish. You know what I'm talking about. There's a this transaction, that is the point, has nothing to do with Amsterdam. Nothing. There's no real minimal connection with the Netherlands, so don't apply Dutch law. All right. Now, 2 things. This was argued by the bank and lessor, solicitors, barristers in court. Apply, Your Honor, please, my lord, apply English law. Why is that not good? Why doesn't that work like this? Well, I can tell you why not. As I said earlier, like United States, Canada, but also England, those are jurisdictions which have several territories, provinces, states in the US, England and Wales, and, for example, Northern Ireland, Scotland, totally different laws, substantially UK law. So in the first place, they should have argued like this, or they should have argued something else than what they argued, but please apply English law because that is where the aircraft is registered. That is not true. The aircraft has UK registration, like India flag, the Netherlands flag, but England is a part of the UK, and the United Kingdom does not have its own substantive property law, mortgage law. It differs from Scotland, England. So the whole argument was nonsense in the first place. Now, can we go to the next place, please? To the next slide. Secondly, chosen law, English law. Why doesn't that work? Now, they had chosen English jurisdiction. Court was ruling. Secondly, to apply, they have said English law, not Scottish law. Why doesn't that work? Well, for the following reason, as I said, choosing a law is fine, but it has, whether it is Indian law, English law, Dutch law, or whatever, it's fine, but it has a limited effect because, ladies and gentlemen, it only works as between the parties, the contract parties. It is a contract, what I said in the beginning of lecture today. Contracts, agreements, lease agreements are okay, but the effect is only between lessor, lessee, mortgagor, mortgagee. The rest of the world has nothing to do with that contract unless the mortgage is registered etc., etc. Then it has third-party effect. But the law chosen, remember that please, because until today, New York also, English lawyers have trouble understanding this. They have trouble understanding that. They think if you choose New York law or English law, it covers the validity of the agreement, it affects the enforcement. No. It doesn't, because third parties are not a part to that agreement, and they don't care which law those two parties, lessor or lessee, have chosen. They say, no, we didn't choose that. We didn't even know anything about your agreement. We don't know what you wrote down in it. We don't know. We are not a party. So choosing a law in international transactions, also Indians, which India, aviation or whatever related, the choice of English law has a limited effect. And that is the only thing that this court did good, rightful. It said, the choice is limited, and we are talking about, is this mortgage valid in that aircraft that was in Amsterdam or not? And can you enforce the mortgage? Now, and you can't, because Dutch law, and of course Dutch law says that the English mortgage is not valid. India will very likely say the same, because I'm sure that in India you have mandatory rules to create a mortgage in a house or land, that the law in India says you must do this, you must do that, and otherwise you don't have a mortgage valid under Indian law. And if you don't do that, like in this kind of case, it was English, so it was not done, then surely I'm sure that mortgage will not be valid in India either. Okay, can we go to the next slide, please? Can we go to the next slide? Now, I told you already, Cape Town Convention, which will be addressed in a moment, shortly. Well, let me do it now. The Cape Town Convention 2001. That is what is intending, and to a very large extent successful, in creating its own international interests. An international interest is like an international mortgage, right? It is a security interest, a secured right, which you can register in the international registry, which is located in Dublin, Ireland. There is one registration system that is for airframes separately, for aircraft engines and helicopters, and the rights, branches in those objects. You can register in Ireland 24 hours, 7 days a week, 24/7, and never closes because everything is done by computer. It is totally computerized. So, and everybody or anybody who has access to that system, not of course everybody in the world, you don't want children to play with the mortgages in airplanes, but you know what I mean. If you've got the login details and you have access to the system, you could yourself, as a lawyer in India and everywhere, you could register those international interests, which are locally in India, Indian mortgage maybe, or Indian whatever kind of secured right, in the international registry in Dublin, and then the whole world can see it in the computer that your international interest is registered, so you can uphold it, it is valid, and you can uphold it and enforce it in all the contracting states, right? Then of course, remember, India, is having issues about implementing Cape Town, but in other countries which are abiding Cape Town Convention member states, you can, without any doubt, enforce your rights, your remedies, etc. And the good thing is that it is not expensive, because to register an airframe separate from the engines, remember, rights in engines are separate and distinct. A mortgage in an airframe, for example, an international interest for $100, and an engine separate, a right in an aircraft engine for $50. Now, isn't that cheap? Which lawyer is doing that work today, international or local, specialized aviation finance lease lawyer, for $100? Nobody, I can assure you, will do that for that kind of fee. I don't know India, but I doubt it also. All right, so it is also very cheap to do so, and then you are certain that your English, Dutch, Indian, interest in that aircraft is registered, valid, and you can enforce it when, for example, the lessee goes bankrupt, or whatever happens, whatever issue arises. Now, what is important is that also this treaty is making it able to create an idea which we will address in a moment. Can we go to the next slide? So, the idea here is that Cape Town is making it more cheap to finance, less economic risk, less legal uncertainty, because you don't need a conflict of laws rule anymore, which may refer you to a location, a situs, which has nothing to do with the transaction at hand. You don't have all those issues anymore. That is what Cape Town is trying to achieve. Now, you guys, for you now, a very recent case, April 30, 2021. So just a couple of months, not even old. SpiceJet. Now, SpiceJet, India, private company, and you know surely from the media, social media in India, that SpiceJet is not doing that grand financially today. It happened before, by the way. SpiceJet, a couple of years ago, I don't remember, let's say 5 years ago, was already on the verge of bankruptcy and reorganization. But now, due to COVID, SpiceJet is not having a jolly time, unfortunately. They can't do much about it, that is for sure, because COVID is COVID, and nobody can be blamed for this, right? But it is for sure having trouble. Now, what happened? The aircraft lessor had, altogether, I think it was concerning, let's say, 5 aircraft SpiceJet. SpiceJet didn't pay the aircraft lessor, which the letter, the lessor, Goshank Shaw, went to court, of course, chose an English law, chose an English jurisdiction. Oh, yeah, I don't want to say how stupid can you be, but anyway, it is the way it is. All right, so they went to English court because SpiceJet cannot pay the lease money to the lessor, which is not happy, and therefore the lessor cannot probably pay the bank which had financed transactions, etc., etc. Now, so lessor, court, UK, England, again, what did the court say? And that's most recent, the lease agreement, right? The lease agreement. SpiceJet said, yeah, well, COVID, I can't pay, blah, 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 blah. And the other one said, yeah, COVID or not COVID, in our agreement, in our lease agreement, it says you have to pay whatever happens in the world, basically, right? That is a typical condition, hell or high water clause. Hell or high water condition. Whatever happens, hell breaks out, high water, you all drown. Whatever happens, you know, that kind of stuff, you must pay. Right? Whatever. And that had been decided by an English court earlier, a couple of years ago, let's say 4 years ago, in a case against Olympic Airways, Greek, at that time still existing, now bankrupt, Greek Olympic Airways, the lessee. There, the court in first court had said, you must pay regardless, because hell, high water clause, you don't have to pay, sorry. And in appeal, the court had said, yes, you must pay hell or high water clauses in the lease agreement, you must pay regardless. So here, one was expecting that the court would say, you know what, hell or high water clause, you, SpiceJet, will have to pay those $25 million money to the lessor. You have to. However, out of the blue, nobody had expected, the whole world didn't expect this, that the court said, well, you know what, this company, SpiceJet, yeah, it is struggling, COVID, can't help it, you know, and that is too bad. And if it goes bankrupt because it has to pay you those 25 million and other lessors also, then it will go bankrupt and it is not in your interest, lessors, banks. Now, this is kind of a very odd ruling, and I'm not sure whether they will appeal or not. I would say yes, go for appeal, because again, this and the previous case, English case, Blue Sky, they are not good for the industry at large. These cases do not give comfort to banks, lessors, etc., to do business. You understand that? Or for higher prices. And then you and I have to pay even more higher prices for our ticket, etc., etc. You understand? Now, so this was the SpiceJet case. Why did they not appeal, by the way, in the Blue Sky case, or may not appeal in this case? I don't know yet about this case, but the reason why they didn't appeal in the Blue Sky case, the financier from New York, is that it had an insurance, and the insurance paid the mortgagee, the bank in New York. So they said, why would we go and appeal? Doesn't make any sense. Costs a lot of time, costs a lot of money. You're not going to appeal. So maybe yes or no appeal in this case. Now, okay, this is it. I want to talk to you about one more Indian case. Can we go, please? Who is doing the one about another presentation, not this one, sorry, we'll skip this already. I know you have it ready, but we'll skip it. Yeah, the repossession. That's it, grand, wonderful, you're doing a great job. Okay, ladies and gentlemen, so far I have been talking about legal practical issues in regard to days that we are closing transactions, buying, what happened until COVID popped up, until the virus issue arrived globally. Everybody was buying new aircraft in India, in China, in Europe, in Africa, everybody. There were not aircraft enough. There were not engines enough. So that is the transactional side. Doing the transactions, like I said, we are doing right now a lease, but then, of course, you've got the other side when, like in Blue Sky or SpiceJet, or due to COVID or not, that the other side, the operator, a private operator, a commercial operator, an airline or a corporation with a corporate aircraft, that they cannot pay their debts anymore. They cannot pay the lease, they cannot pay the mortgage, then you get issues. So that is the other side. And by the way, that is nice for international aviation financing and leasing lawyers, because you have good days, it goes in cycles, remember, the great days, sky is the limit, everybody buys, everybody leases, everybody finances, transaction, 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 and then all of a sudden it collapses, the bad days, and you turn the table, the lawyers, and they are going to do repossession work like the one at hand. Repossess. You want to get your aircraft back. You want to get your money. You get back, you try to get back that aircraft. Next slide, please. Wonderful. This is a pure international, but Indian, it is an Indian case. And it is, I can already tell you, the worst case in the history of international aviation financing and leasing world. It is already going on for 11 years, and maybe yes or no, soon a solution, but maybe yes and maybe no, that is not 100% sure yet. Okay, what is happening? Can you see that lovely, nice corporate jet that used to be operated by a certain Mr. Lalit Modi? The Indian gentleman was in charge at that time of the Indian Premier League, the cricket matches, etc., etc. You will, people in India, cricket is very important, and many of you may know still the name of Mr. Modi, who was flying. He was not a pilot, obviously, but he didn't operate it physically himself, but he was leasing it, his let's say, his companies, whatever he was behind, the ultimate beneficiary was Mr. Modi, until the government of India started tax fraud case against him, and as far as I know, Mr. Modi is currently, and his wife, left India and are living in London, the place to be. Now, okay, so what happened? It was a very nice case. Can we go? You see the Bombardier, nice, and you can see it parked right now until today at Biggin Hill Airport in United Kingdom, which is near a smaller airport near London. That's where it is already, I can tell you, 11 years. And you can see physically, they try to maintain it. The engines have been covered a bit in detail. You can see things, but you can imagine if an airplane is, whether it is commercial or not, like remember the commercial 777 Jet Airways aircraft, which is probably still already 2 years at Amsterdam airport standing there. It doesn't do good to your airplane, and the value is going down and down and down. Even if you maintain it, the engines are not working, and you have to pay every day airport fees, which is a lot of money. So it is a big mess. Next please. Can we go next slide? All right. What happened? Peel, okay, is lessor in Ireland, Irish lessor. There are many lessors are in Ireland. And why are all those aircraft lessors, engines lessors, and banks also, investors, why are they all in Ireland? There's only one reason, and that is because they pay very low tax in Ireland. So it is not because Ireland is such a wonderful, nice, it is, there's nothing wrong with it, but it is not because of the climate, it is not because of the this or the that or the weather or I don't know. No. It is only for one reason that the aircraft lessors and banks, etc., are in Ireland, and that is because of the tax, right? Very simple. Now, so also Peel Aviation Ireland, lessor leases to Mr. The guy, let's say the lessee, Golden Wings, lead behind it, ultimate beneficiary, leases this aircraft, all right, 2008. Okay, and you must know that India ratified Cape Town in 2008. So Cape Town Convention remedies are applicable to this transaction. It just entered into force July 1st, 2008. India adopted, and this lease we are talking about, to make it simple, was entered into, I believe, let's say July 20. All right? So Cape Town was applicable here. Now, the mortgagee is in the United States. It's called corporate aircraft funding, and the cases are against the state of India, right? The state of India. Okay, corporate aircraft funding is mortgagee, bank, United States. It gives 40 million to the lessor to purchase the aircraft. It gives a loan with an English mortgage, again, of course, English mortgage, in 2008. Now, both the lessor and the lessee and lessor are defaulting under, respectively, the lease and mortgage agreements. In 2010, they cannot pay. All right? Mr. Lalit Modi, what's his name? He, because of the tax fraud accusations, etc., one thing came to another. Well, in any event, what is important, that airplane is taken out of India, flying out of India, orchestrated, it was arranged to do so, not one day to the next, okay, we're going to take it out. No, this has been arranged already in 2010. And 2010, July 23rd, as you can see, it is already at Biggin Hill, near London, right? So that is now almost July 23rd, 11 years, but it is out of India already 11 years. However, the Department of Civil Aviation of India refuses to deregister this aircraft from the aircraft registry in India. And it is despite the fact that India has adopted this treaty. It applies. Under the treaty, the aircraft financier, mortgagee, corporate aircraft funding, has a document obtained from the lessee, the debtor, that it is the only party that can, whenever it decides to do so, go to the Indian Department of Civil Aviation and ask and tell them, basically tell them, to deregister that aircraft. That remedy is provided by the Cape Town Convention and applied here. You must understand that. So that is what corporate aircraft funding was doing already in 2010 for the first time. It said to the Indian authorities, deregister that aircraft because then I can lease it out to somebody else or sell it again. But first you must deregister in India because I cannot register that aircraft in another country. It cannot be done before you deregister it. Because the law says that you can only have one nationality, Indian or UK or Netherlands. You understand? Only one. Validly. That is what it is. But, as I say, until today, invalidly, totally contrarily to the Cape Town Convention, because there is no discretion here. The government cannot say, oh yes, maybe I'm doing it, or no, I'm not going to do it, because there is a tax fraud case here, or whatever. No, that's not permitted under the Cape Town Treaty. So the Department of Civil Aviation is committing a tort. It is a governmental tort. In my book, it is a governmental tort. I'm not sure whether you in India can call it this under Indian law, but internationally seen, and certainly in my country, if it would be my Department of Civil Aviation here in the Netherlands refusing to do it, and Cape Town would apply, etc., all requirements are met, I would say, okay, DCA, court case immediately to my client, we are going to sue DCA, the Netherlands, because they are committing a tort. They are not doing something which they must do, and therefore it is illegal because the law says so. The treaty says so, and the treaty applies. So it is a tort. So pay damages to my client until you do whatever it has to be done. But India, I don't think probably you can do so. Now, can we go to the next slide? We are almost there, you guys. In India, what happened in India? Can we? Yes, this is it. Lovely. There were two court cases, by the way, in India in 2013. Corporate aircraft funding cases, State of India, to call them simply this. Okay, 2013. First case, corporate aircraft funding, Union of India. Right, the court said here, the judge, very correctly, properly, appropriately, whatever you want to say, adequately, everybody happy, said, you know, Cape Town Convention, DCA India, you must deregister that aircraft. You must. Okay. India government, now Directorate of Revenue Intelligence, the tax people, let me call them, versus corporate aircraft funding. A little bit later, this court in appeal, it totally ignored in its ruling that the Cape Town Convention existed. Evidently, the parties representing, the lawyers representing corporate aircraft funding, they argued, you know, you have to apply the Cape Town Convention, it applies. Look here, this. India adopted this. Okay, what did the court say? Nothing about Cape Town Convention, totally ignored its existence, and it said, you know, DCA India, I think within 3 months or so, whatever it said, you must decide registration, etc. Now, this was totally infringing the goal, sphere of application of Cape Town Convention. Totally. So the whole world was shocked. And then what happened next, you guys, is that, as said, in Ireland, that's where all the lessors are. Well, the lessor finally went bankrupt in Ireland, Paul, Beale Aviation, remember, an Irish lessor, a special purpose company. Its only asset, remember, special purpose vehicle is the asset, is the aircraft, nothing else. It has no other assets. It has no people working for them, employees or anything. Doesn't, well, anyway, but it went bankrupt in 2019, April 1st, because corporate aircraft funding, the bank in New York, located in New York, it asked for its liquidation. See? However, until today, the Irish liquidator has not sold or leased anything, done anything with that aircraft, still grounded. Why? Because, very simple, because India did not until today deregister the aircraft, so it is worthless because you cannot lease it out to another party, you cannot sell it to another party, because the new party, lessee or operator, cannot register it in essence. They think. You understand? Can we go next slide, please? Now, you see, what do international treaties say about registration, deregistration? That is the issue at hand here. Now, if you have taken other aviation law courses already, or lectures like this, you know that there exists a Convention International Civil Aviation, Chicago, Convention 1944, an older one, which has been, remember, I told you that yesterday, ratified by India also. Now, and that says basically what I told you, you can only validly, underline validly, register that aircraft in one state, validly. So, the question is, when is or where is an aircraft validly registered? Because it also says, this treaty, you can transfer a registration. You can deregister, for example, in India, and register it subsequently in the Netherlands. That is all right. There's nothing wrong with that. See? So the question is it still, in brackets, validly registered? Now you wonder, is that certain aircraft we are talking about here, that Bombardier corporate aircraft, is it still validly registered in India? Now the answer is obviously no. I told you, the government commits a tort. It is invalid. It is no longer validly registered in India because the applicable law, data convention, says it is invalid what you're doing. So it's no longer valid. So that is my point, that you can now validly register it without a problem in another country, because it is no longer validly registered in India. Then despite the fact that the Indians don't give you a little paper saying that it is not valid, or that it is still registered in its book. Let's say it is still a book, it is not. I think not, it has a different registration system. But let's say it should write out, just, you know what I'm talking about, in its computer or whatever. But it is still allegedly registered, but it is obviously invalid. And you know what? The Chicago Convention, that is the point. It says only validly registered in one state, but you can also transfer registration. But Chicago Convention does not say how to register or deregister. That is up to every individual state, how to register or deregister. The process, the procedure of registration, procedure of deregistration is up to India, is up to the Netherlands, United States, etc. Differs. And some have good registration laws, and some have not. Okay, unless there is a new, later than Chicago Convention 1944, ICAO treaty that dictates a uniform deregistration procedure for all its member states. And lo and behold, is there such a treaty? Yes, Cape Town Convention. Can we go to the next slide, please? Cape Town Convention, look at it, applies, remember, you've seen this yesterday, in all these states, and lo and behold, that applies also in India. And Cape Town exactly says, you must deregister India, you have no choice, obligatory, no discretion, yes or no, fraud or no fraud, he didn't pay taxes. And by the way, what has the bank in New York got to do with Mr. Lalit not paying taxes? Right? The fraud, if there is a fraud, has not been committed by the bank in New York, has it? Has nothing to do with it. So why making things difficult? Now, you know, this is not good for the reputation of India. I told you, this is not India bashing, but things like this are not good for the reputation. And you may wonder, why is Indian government doing this? Why? Why? That's not good for its reputation. That means legal uncertainty. What is the law applicable in England? They won't follow up, etc. The court doesn't even mention Cape Town is existing. This is no good. So we will do business in India, of course, because it's a big, big market, right? Normally, COVID, different matter, but that will end one day. Big, big market. And what are we going to do with all these airplanes? Okay, we'll accept the risk. Let us lease to India, to these airlines or corporate aircraft. Why not? What else are we going to do with these airplanes? We will do it, but that is the other side, for higher, unnecessary high costs. The operators, airlines, corporations have to pay through the nose. You have to pay airline tickets. How many times do I have to say it? Right? You see? So it is not good. And why do you adopt treaties if you don't abide to them? Why? It's not good for its reputation, honestly. Now, okay, can we go next? Well, how can you solve the corporate aircraft case? Now, and lo and behold, here we go, my country, the Netherlands. Okay. Okay, one more, please. I already discussed this. One more, further. Here. One back, please. Lovely, lovely. In the Netherlands, where I'm located, my government has introduced a totally novel implementation of the Cape Town Convention rules concerning deregistration, registration of aircraft. And it was entered into force on April 1st, 2020. So it is a recent law, novel, in the sense that no other country in the whole world has yet implemented the Cape Town Convention registration, deregistration, particularly rule in its local law in this manner. Not one country in the world yet, and I think they should follow up, and it would be good for India to do it, because it would be very good for its reputation to do the same, to create similar laws and apply to it. All right, my government, and I must say, my firm, my law firm, and specifically little me, I was the external legal counsel for my government in this respect. By the way, I was also the legal external counsel where my country, the Kingdom of the Netherlands, adopted the Cape Town Convention, and here the same. the government introduced the following rule of law. If an aircraft is imported, like from India, right now that's corporate aircraft funding aircraft, wants to, the owner, whoever stakeholder wishes to register it in the Netherlands, and we call it imported. Not physically needed, you don't have to physically do so, but legally you import it. Now, then proof has to be submitted, you understand, that the aircraft is not or no longer registered abroad, but that doesn't work here, right? Because the Indian authority refuses to do so. It doesn't come up with a document saying that it is deregistered. So it is not easy, only you can argue that it is not validly registered there anymore. But anyway, you can register in Holland, in the Netherlands, not Holland. We call it, of course, not Holland. That's not a formal legal term. In the Netherlands, when you can prove with a document, for example, it is no longer registered in India, but that doesn't work. Now it comes to new thing, or the aircraft must be deregistered from a foreign registry, India in this case, under the Cape Town Convention rule, IDERA, Irrevocable Deregistration Export Request Authorization. That is what we call in practice an IDERA, a document saying, okay, the DCA India must deregister when the stakeholder, here being corporate aircraft funding, the bank, asks for it. Okay, you see? So if the Cape Town Convention applies, like in this case, then you can now register this aircraft in the Netherlands, because that is the idea behind it. Cape Town Convention is applicable, and what India is doing, DCA, is invalid. It is no longer valid there, registered validly. So you can register it now in the Netherlands. You get the Netherlands flag, PH registration, like in India, VT India, right? You get the temporarily, so you get the Netherlands registration, and subsequently you can register that aircraft if you wish. Whenever it suits you, you deregister it from the Netherlands and you register it in a third country. So you get a new lessee operator, airline corporation that can fly that without a problem, that airplane. So it does not have to be grounded 11 years anymore. There is only one requirement under 3 first. You must have asked DCA India to deregister. Now in this case that has happened several times and they keep saying no until today. Maybe tomorrow they'll change, maybe. Okay, and the applicant, the one who asks for registration in the Netherlands, must do a transaction via the entities where Cape Town in the Kingdom of the Netherlands applies. That's very simple. You just start a special purpose vehicle in such a territory. You see those names, Bonaire, Aruba, Curaçao, St. Martin, those are territorial units which are still a part of the Kingdom of the Netherlands. Old colonial days, like the UK, has all these crown dependencies still, right? Bermuda, whatever they've got. You know what I'm talking about. The Netherlands Kingdom still has that too. Now, and that's it. So, if you wish, you can solve this, that's my point, and then I'm ready. The liquidator in Ireland could have already, since April 1st, 2020, taken this route. It could have. But however, it didn't. yet it is still waiting for India to deregister. The aircraft is worth millions less than necessary because it has been grounded now for 11 years and it has not been maintained lately. It could take this route. Ignore India, say to India, okay, you can do whatever you like at home, but internationally, this is the way it is. This is how it works. So, but it didn't. Why? I can only say, I can only guess. I have no idea. But there are some issues, and one is, I know that for sure. Again, and when this law entered into force, it has been inquiring and asking a law firm, trying, getting advice about registering it outside India. But it got wrong advice again. So my final words are repeating myself that always be careful that you choose a law firm which really has expertise in regard to aircraft finance and lease laws, and don't go just to the largest law firm or allegedly the best law firm in the country because it does so nice corporate law, it does so nice criminal law, it does such a good way commercial transactions, whatever it does. But one thing, it has no expertise, it doesn't know anything. The court cases I mentioned to you, some already prove it. Those were big law firms, for example, in London, but with bad aircraft finance and lease lawyers. You have to be very careful. Later, if you start working for a corporation or whatever, and you hire, retain a law firm, and it doesn't matter whether it is aircraft finance or lease, anything, or just don't go to a law firm where you already have some kind of relationship with, because you retained them earlier for different cases, totally different cases. Now, that is what I wanted to say. Thank you for listening. I took a long time, but I hope you don't mind. We have this opportunity right now provided by your grant organization, which is absolutely wonderful, and therefore I took a bit more time. But if you have any questions, I am at, for example, you know this, at LinkedIn. When you Google, you can find my contact details about whatever you like. You can approach me. I have no problem with that at all. And also now, if you have any questions right now, do not please hesitate to ask right now or later. And questions are always welcome and never bad. Some people are shy. I told you yesterday, the law industry is not a place to be shy. It doesn't work like that. So, that's it. Does anybody have a question? Otherwise, we'll be stopping and I say goodbye to you. Nobody questions? Nobody? This is the moment to ask. Well, no? Nobody else?
Good evening, sir. Am I audible?
I hear a lot of noise. Okay. Anybody a question? No? Then we'll say goodbye. And thank you for listening.
Sir, before you leave, may I proceed with the thank you note?
Sorry?
Before you leave, may I proceed with the thank you note?
Go ahead, do whatever you need to do. Is that, yeah?
So thank you for a wonderful session, sir. I take immense pleasure in rendering today's vote of thanks to you. On behalf of the whole organization, I thank you for connecting with us and enlightening our participants on this topic. I thank all the participants who have joined us today. Thank you for your cooperation and enthusiasm. Lastly, I would like to thank the Amicus Curie for providing such an outstanding opportunity to its participants. you everyone for joining us today. We look forward to more such successful and insightful sessions.
Well, thanks and goodbye everybody from the Netherlands. Wishing you all the best with your future careers. All right?
Thank you so much.
Thank you, sir. Thank you for listening.
Thank
I
you,
really
sir.
appreciate it. Okay, thank you. I see all very kind notes popping up. Bye-bye. Take care. Bye-bye.